To the 2011 Charles S. Desmond Moot Court competition. I'd like to say congratulations to the competitors for making it this far. We've had some of the best students with appellate advocacy skills here on this year's competition as opposed to years in the past. I'd like to thank the Moot Court board. I think more this year than any other year. They showed their commitment to this program by working really hard together and making this thing go off. And I just want to say thank you to all of them. I'd also like to say thank you to Professor George Kneller. Whenever we needed any sort of mentoring or advice, he was there to help us out, and he's done a great job as director of the Moot Court program. We are honored this year to have Judge Eugene Piggott from the New York Court of Appeals, Judge Jeremiah McCarthy, Magistrate Judge from Federal Court for the Western District of New York, and the Honorable Aaron Peredato from the 4th Department of Health Division. Without further ado, they will be out shortly.
All rise. Thank you all. Please be seated. Welcome to the 2011 Charles S. Desmond Moot Court competition. This year's competitors will be arguing the case of Smith v. State of Desmond. On behalf of the Buffalo Moot Court Board, I would like to thank the judges for volunteering their time in making this competition possible. Shortly, we will begin the round with arguments from the petitioner and conclude with arguments from the respondent. Judges should take a moment to familiarize themselves with the scoring process. We will now begin the round. Oyez, oyez, the United States Supreme Court is now in session. Presiding are the Honorable Justices McCarthy, Piggott, and Peredato. Chief Justice Piggott presiding. Hearing the case of Smith v. United States.
Thank you very much. I'd like to thank the University of Buffalo Law School on behalf of Judge McCarthy and Judge Peredato for having us here. It's an honor to be here, and from everything we hear, this has been quite an inspiring competition, and we're going to be hearing from the best of the best, as I understand it. To my right is Judge Jeremiah McCarthy. He's a federal magistrate judge. Judge McCarthy is a product of the University of Notre Dame and Cornell Law School. He couldn't get into UB. No, I'm kidding. To my left is the Honorable Aaron Peredato, who sits on the Appellate Division 4th Department and is a graduate of the University of Buffalo and the University of Buffalo Law School. I'm Judge Eugene Piggott. I went to Le Moyne College and UB Law School as well. So we have a vote of 2-1 no matter what McCarthy does. But we're looking forward to your arguments, and I want to encourage you to relax. We'll try not to be too much of a pain. We'll be asking you some, I think, incisive questions. I guess, are there time limits here? Who's keeping time? You are?
Yes.
And what are you doing, holding up cards?
Yes.
The only reason I ask that is, generally speaking, you're lawyers. You may feel like law students now, and you still are. But as far as we're concerned, and for the next hour or so, you are attorneys, and we expect you to act as any attorneys would, and that means keeping an eye on the time. And if you go over a little bit, we're not going to get too upset about it. If you go over it a lot, we're probably going to get a lot upset about it. I'm kidding about that too. But keep an eye on the time, and we'll hear your arguments, and then what we'll try to do is interrupt you as politely as we can. But we will have questions as you go along. So may we hear from the petitioner?
Good evening, Chief Justice and Your Honors. My name is Corey Forster, and I, along with my co-counsel, represent the petitioner in this case, Ms. Chloe Smith. And before I begin, I'd like to reserve 2 minutes of time for rebuttal.
Yes.
1 minute. Thank you.
Sorry.
1 minute for my time and 1 minute for my co-counsel.
Okay, one each.
May it please the Court. Chloe Smith was an exceptional high school student. She was junior class secretary. She had the opportunity to attend the University of Desmond on a full scholarship. Unfortunately, she lost this opportunity due to 2 needless and unwarranted blemishes on her record. And these blemishes stemmed from violations of her constitutional rights. Specifically, there are 2 constitutional issues that arise out of the case before Your Honors this evening. I will be addressing the First Amendment issue. My co-counsel, Frank Ewan, will be addressing the Sixth Amendment issue. Would the court care for a brief recitation of the facts?
I think we understand the facts, so you go right to the argument.
This court should rule in favor of Ms. Smith for 3 reasons. First, her speech had no tendency to cause, nor did it actually cause, any substantial disruption in the work and discipline of the school. Second, because of this, it was entitled to full protection under the First Amendment of our Constitution. And finally, the speech fell outside the purview of the school's power because of how far disconnected it was from the school environment. Specifically, it was contained on a public forum and qualified as non-school sponsored material.
Well, Counsel,
Go ahead.
are you suggesting that the school has no power to control speech outside the boundaries of the school?
No, Your Honor, I'm not suggesting that at all. However, as the Ninth Circuit held in Birch v. Barker, non-school sponsored material is not subject to school control. The Second Circuit has upheld this standard in Thomas v. Board of Education, in which a student distributed a parody magazine off campus, and because it was non-school sponsored material, it was not subject to school control. And further, BigJournal.com, the website on which the blog entry was posted, is a public forum. Now, if Ms. Smith's speech was contained in some non-public forum over which the school has power, such as a school newspaper, as in Hazelwood v. Kallmeyer, or had Ms. Smith verbally recited the speech in the school, as in Bethel v. Fraser, then the school could have placed restrictions on it.
What was the net effect on her of what you claim to be an abridgment of her free speech rights?
Well, Your Honor, there were several things. First, she was removed from her position as junior class secretary. She was barred from running for senior class secretary. She had to inform her mother of the entire situation. She was forced to apologize to the vice principal, and she received a negative disciplinary mark on her academic record that resulted in her losing the scholarship to which she was entitled.
Would you be making the same argument if she had posted this message on her laptop in the school building during school hours?
If it created a substantial disruption within the school, then it was within the school's power.
Okay, so that's your real argument. It's not, you're not focusing on on her, where she was located when she did this posting, the fact that she did it from home?
Well, respectfully, Your Honor, it's both. There was no sufficient nexus here because she was off school grounds, and it was after school hours on a public forum with which the school has no affiliation.
But
And
clearly the impact, but clearly the posting was intended to have an effect on school grounds, wasn't it?
Respectfully, Your Honor, I disagree. There were two entries of speech here involved, only one of which is at issue, and I'd like to draw a distinction between the two at this time. On the first day of this incident, the student council sent out an email, and that email urged its recipients to contact the school administrators and essentially badger them regarding the Jam Fest incident. Now, an email by its very nature is invasive. Once it's sent to you, it arrives in your inbox and there's nothing you can do to stop it. You're going to receive it. However, the blog post, by its very nature, is idle. It's essentially a journal entry that you post on a telephone pole. It's idle. Unless you seek it out, you're not going to find it. It'll never make its way to you. Now, the blog entry here had no call to arms, unlike the email. It urged no action on anyone, unlike the email. In fact, mostly it was a passive recount of the Jam Fest scheduling incident. Now, at the end of the blog entry, she posted a letter, and that letter could be used by other students or interested parties to contact the administration at the academy if they were displeased with the academy's actions. However, she posted it as a take it or leave it kind of letter.
The no disruption point that you make, I mean, suppose this email had nothing to do with Jam Fest or anything like that, but it was excoriating a fellow student. Could the school give her this poor citizenship black mark anyway?
Your Honor, that situation is akin to the Kowalski case, in which a student made a MySpace profile, and it seemed as if the entire rest of the school joined in and cyberbullied this other student, and that created a disruption. And it may not have created a disruption in the school. However, I believe it did in that case, but that fell into the purview of the school's regulation power because of how severely it affected another student.
If it did not disrupt, what about that?
If there was no disruption whatsoever, then the school could not regulate it.
So she could excoriate a student, and the school could find out about it and say, this is not the type of student that we want to see going to college, but there's not a darn thing we can do about it. She can call an African-American student anything she wants. She can call a gay student anything she wants, and she's going to represent as a graduate of our school in college, and the courts, are going to tell us there's not a darn thing we can do about that. She can be as mean and rotten and nasty and poor citizen as she can possibly be, but if she doesn't, and it doesn't disrupt anybody, it's okay.
Well, not necessarily, Your Honor, and I understand your concern. Allow me to amend what I just said. I misunderstood your initial hypothetical there. If it created a foreseeable a reasonable forecast of disruption, then the school could also restrict it. However, here the speech created no reasonable forecast of a disruption and created no actual disruption.
Now, I'm surprised you're saying that you can say anything you want about people and the school can't judge you for that unless and until there is a, quote, disruption, unquote. Because I would think if someone was making those type of remarks as I outlined, that whether it's a disruption or not, the school would say this is not the type of person you want to send out to college.
Yes, Your Honor. And
I didn't mean to interrupt you. Finish and I will call that.
Yes, Your Honor. I'm not arguing that they have to wait for a disruption to occur. As this court held in the seminal case on student speech rights, Tinker versus Des Moines Independent Community School District, as long as there are factors that would lead to authorities to believe that there's a reasonable justification for a forecast of disruption, then they may take appropriate action. However, on the facts of this record, there was no reasonable forecast of a disruption because of the passive tone of Ms. Smith's blog entry and because of the idle nature of blog entries in general.
Isn't there actual evidence that there was a disruption? The principal and vice principal were disrupted from many of the activities, the school activities, for several days, and received all sorts of letters and calls and comments relative to this Jam Fest. Isn't that disruptive? You're not conceding that that's disruptive?
Yes, Your Honor.
Substantially disruptive?
Your Honor, it was disruptive. However, I'm arguing that it was not substantially disruptive. It's within the school's responsibilities to field complaints regarding their actions. Now, judging by the influx of phone calls and emails and whatever other contact they received, it's clear that this Jam Fest event was very important in the community. The email that the student council sent out reached students, parents, and others, and they all contacted the administration regarding that event. And because the school administrators were the ones who put the event in limbo by moving it from its scheduled date and place, then they were responsible for fielding the complaints that would result from that action.
How about completely aside from the issue of disruption, how about the statement on the blog, Jam Fest is canceled due to certain types of bags in central office? It's not something particularly when that's going to be accessible by the public. The use of that phrase, are you saying the school is powerless to make any comment on that student's character as a result of her use of that phrase?
Well, Your Honor, unless it created a foreseeable disruption, then it falls outside the school's purview, the purview of the school's power. Now, this court in Chaplinsky versus New Hampshire outlined the elements of unprotected speech under the First Amendment. This includes speech that is lewd or profane, obscene.
And that's not?
Lewd or profane?
Yeah.
No, Your Honor, I believe that's restricted to the 7 swear words. Obscene, libelous, or insulting or injurious language that by its very utterance tends to incite an immediate breach of the peace. Now, here the principal stated that the language tended to encourage others to incite confrontation. However, aside from the fact that this is merely the principal's opinion, confrontation is not akin to a breach of the peace. In fact, controversial speech often tends to incite confrontation, and this court has embraced that very principle in Tinker.
What about the last line of the blog post? It seems pretty insightful to me, doesn't it? Isn't it to you?
Could you,
That's what you want to write, if you want, or refer to here's the letter that my mom sent to the principal, if you want to write something or call her to piss her off more. Write something or call her. It seems pretty insightful, no?
well, she posted it there if anyone wanted to call them. She did not urge anyone to call them. She did not encourage them to do it. It was up there as a take it or leave it kind of measure. Now, as Justice Fortas stated in the majority opinion of Tinker, any word spoken on campus or in the classroom, in the lunchroom, that deviates from the view of another may create a disturbance or a confrontation, start an argument. But our Constitution says that we must take this risk. The speech is not unprotected simply because it's controversial, or because it may start a disturbance or an argument or a confrontation. Because Ms. Smith's speech.
Let me interrupt you again.
Yes.
Let's assume that there was a substantial disruption. Does it matter to you, or does it matter whether the discipline that was imposed was retaliatory?
No, Your Honor, if they're, I'm sorry, if I
In
understand,
retaliation for the speech itself.
if the punishment had no other reason but for, if it was a retaliation, is that what you're asking me, Your
Yes,
Honor?
yes.
No, well, that would depend. It would depend on whether it was still the regular punishment of how the school would deal with it. If it was within the principal's purview to inflict that punishment regardless, and she merely inflicted that punishment as a retaliation, then she could still do it. However, if that punishment was not in place and it was not within the school's power to inflict that punishment on Ms. Smith, then yes, that would matter. However, here there was no substantial disruption. There was no tendency to cause a disruption. And BigJournal.com, as I stated previously, is a public forum. Ms. Smith posted her speech on this public forum after school hours, at her home, on her own computer. And therefore, it was non-school sponsored speech, non-school sponsored material. And that falls outside the purview of the school's power. To paraphrase the Third Circuit in JSV Blue Mountain School District, if we were to punish Ms. Smith for speech that is so far removed from the school environment, we would reach into the family home and unconstitutionally punish Ms. Smith for her conduct. And therefore, we respectfully request that this court find the principal engaged in a flagrant abuse of her discretion by restricting Ms. Smith's speech. And also, we request that this court vacate the decision below so that Ms. Smith may have the negative disciplinary marks removed from her record. She may receive the scholarship to which she's entitled. I thank you, Your Honors, and my co-counsel will now address the Sixth Amendment issues that arise out of this case.
Thank you, sir.
Thank you.
Justice, Your Honors, may it please the court. Don't worry about the photographic evidence they have against you, because they won't be able to prove anything with it. Don't worry about the sentence the judge will give you, because you're likely to get probation. These are the words and the actions of Ms. Smith's counsel. And as a result of these words and actions, Ms. Smith had her Sixth Amendment right to effective assistance of counsel violated. Now the record?
The issue really comes down to prejudice, doesn't it?
That's exactly right, Your Honor.
There's a very big difference, although you say perhaps not, but it seems to me that there is a difference between a defendant's choice to accept a plea offer or reject a plea offer, and that's what we're talking about here, right?
It is, Your Honor. The court's seminal opinion in this case is Strickland versus Washington, a decision that this court laid out in 1984. And in fact, yes, it is a two-part test. The first part of that test is to show, in fact, that counsel's representation was objectively deficient as a matter of law, something that the lower court conceded. And the second step is to show that there was prejudice as a result of that objectively deficient representation. However,
Counsel, how do we know let's assume she had decided to take the plea offer. It's still subject to the approval of the court. How do we know that approval ever would have been granted?
well, Your Honor, this court said that as long as there's in Strickland, as long as there's a reasonable probability that the petitioner would have been, or the criminal defendant, would have been in a better position but for the ineffective assistance. All we need is a reasonable probability that she would have been in a better position in this case. Now, to go back to Your Honor's question, this court in Strickland also said that this is a totality of the circumstances argument. And so while, as the lower court has conceded, the specific facts of counsel's objectively deficient representation are not specifically at issue with respect to the first prong of the analysis, it's still important to note the court always considers what counsel did as a result. Now here, counsel failed to look at the photographic evidence related to Ms. Smith's claim.
I think we can assume that counsel's performance or that counsel was ineffective. The question in my mind is whether is the prejudice prong of Strickland. And with respect to someone who takes a plea, who accepts a plea, when they do that, they forfeit constitutional rights that are associated with a jury trial, not the least of which is the right to a jury trial. But when they do not, when they decline to take a plea, they're not forfeiting any constitutional rights. They're accepting their right to go forward with a jury trial. So I guess that's the problem I have with the prejudice.
Your Honor, this court held in Hill v. Lockhart in 1985, and its progeny, Iowa v. Tovar in 2004, as well as Padilla v. Kentucky in 2010, that Sixth Amendment rights attach during the plea negotiation process. Now, the court reasoned in all of those cases that the plea negotiation process is a critical stage of criminal litigation.
I don't dispute that, but why shouldn't we treat why shouldn't we treat cases differently when, or defendants who accept a plea and defendants who reject a plea differently, because in one instance they are forfeiting constitutional rights and in the other they're not?
Your Honor, I think we need to, from a policy standpoint, we need to consider the number of criminal defendants that receive a plea. Now, it's a well-known fact that not every case in criminal litigation goes to trial. In many of these cases, a criminal defendant is offered a plea. Sometimes they plead guilty, and other times they plead not guilty. Now, if we don't extend this court's previous decisions to not guilty pleas, we run the risk that this wide number of criminal defendants will have a potential Sixth Amendment effective assistance of counsel issue.
Counsel, here the government, the prosecution was not at all at fault for the situation. They then went through a trial, which would have been the benefit to them of a plea deal. The reason that the defendant would have been offered a favorable disposition is in part at least to save the government from the time and expense of going through the trial. They've had to bear that expense, and now I take it you want them to nonetheless lose the benefit of that bargain so that it can be given to the defendant. Is that right?
Your Honor, we want to put Ms. Smith in the position she would have been but for counsel's ineffective assistance.
But you can't put the government in, you can't put the prosecution in that same position, can you?
Respectfully, Your Honor, the circuit courts have been quite clear that you can. In a recent decision in Williams v. Jones, Nunes v. Mueller out of the Ninth Circuit, as well as the United States v. Gordon in the Second Circuit, the courts have not considered the cost or burden to the state to retry, or in some cases, to put the petitioner in a position that they would have been but for the ineffective assistance. So this court can, in fact, fashion a remedy such that the petitioner is put in the place that she would have been.
How do you see that playing out? Because you're absolutely right. Most cases are pled out in one form or another. But those that go to trial, a fair number of them, let's assume, get convicted. Why would any of them not immediately file a motion to set aside a conviction based on ineffective assistance of counsel, saying, everybody knows I had a good plea offer beforehand, I didn't take it, he told me not to, and I got convicted, so let's go back to square one?
Your Honor, the reason that we have to consider the totality of the circumstances...
Well, where would you draw the line? In other words, you're going to get to write the law now. What's the law going to say in terms of how we handle cases where people have been convicted after a jury trial and end up getting a sentence worse, or a conviction worse than what they would have on a plea?
Your Honor, I understand that you may have asked two questions, and I will try to handle them both. The first question, Your Honor, is we look at the totality of the circumstances under Strickland. And in this case, we have a teenage, indigent high school student who doesn't have the same breadth of knowledge of the law that we have.
So are you going to say, if you're under 21, this rule applies, if you're over 21, it doesn't?
Your Honor, we're not trying to create a bright line rule.
Well, unfortunately, we have to. Any decisions we make are going to apply to all 50 states. And so we can't say what I think you would like us to say, that in this specific instance, there was a violation of the Strickland rule, without explaining why this one's a violation and some other one is not.
Your Honor, again, I think we need to go back to the fact that this is a deferential standard of review. So that's not to say that we would open the floodgates to a litany of Sixth Amendment effective assistance of counsel claims. And in Strickland, again, the court said that is the standard of review. That's a high standard of proof. There's also the first part of the Strickland test, which says that it has to be objectively deficient as a matter of law. So this can't involve counsel's interpretation of a statute, as it did in Lockhart v. Fretwell in 1983. It can't involve a lot of these things. What it does involve is an objective decision to see if counsel first was objectively deficient. What we are asking, and the circuit courts have been quite clear about, is that when we consider the facts of the case, that we put the petitioner back in the position they would have been but for counsel's ineffective assistance. And again, I think Newman's
specific performance of the deal is what you're seeking, right?
Not necessarily, Your Honor. All there has to be is a reasonable probability. As Your Honor has said, there is no guarantee that the court will approve.
If we grant the relief you want, you're gonna, your client then is gonna be able to plead guilty pursuant to the plea bargain, right?
That's what we hope, Your Honor.
There was no promise of a sentence, that I recall. You just said that this judge is lenient.
That's exactly right, Your Honor.
Can the judge sentence her 10 days of shock?
That pursuant to the statute, yes, the judge could, Your Honor.
So what are we doing?
Judge, respectfully, we're putting Ms. Petitioner Smith back in the position she would have been but for counsel's ineffective assistance. And what that means is we put her, a indigent teenage girl, in a position where she understands her penal and pecuniary interest. Now, when counsel told her that she would receive potentially, if counsel had read the statute anyway, he would have told her that she would be subject to a 10-day sentence. And he told her that she would only get a 3-day sentence. Now, her liberty was suspended for an additional 7 days. That's almost three times where she would have been but for counsel's ineffective assistance. And there's also a pecuniary interest here, Your Honor.
Was the 3 days promised?
3 days was promised by counsel.
Was it promised by the court?
Absolutely not, Your Honor.
So it's conceivable that you could win this case. She goes back in front of that judge, and I don't know what your lawyer was telling her, you're getting 10 days for the plea.
That is one possibility, Your Honor. However, even if we put Ms. Smith back in the position she would have been, it's also a possibility that she would receive another trial. And under that case, as we saw in Iowa v. Tovar, in that case, we know that criminal trials often, when they go back, there can be two different results.
So you're not asking for the plea bargain. You want to go back to the arraignment.
Well, Your Honor, we don't want to have this court order a plea bargain to the state of Desmond, create an issue of state sovereignty. But circuit courts have said that you can vacate a charge against the criminal defendant with an instruction that if the plea bargain isn't put back in place, all the charges will be released. And again, that comes out of Nunes versus Mueller in the Ninth Circuit.
I'm trying to follow the logic of your request for a new trial when she's already had a fair trial. You're saying that you want us to remit it to the lower court to vacate the conviction so that she can have the opportunity to have a second fair trial?
Your Honor, respectfully, what I'm saying is that there's a number of remedies open.
So it sounds like you want her just to have the chance to roll the dice again. That's what I guess my point.
Respectfully, Your Honor, what we would like is for Ms. Smith to be put in the position she was before counsel's ineffective assistance. Now, that may in fact be a chance at another plea agreement. That also may be.
Why wouldn't you just want the plea?
Respectfully, Your Honor, we do want the plea. What we don't want to do is have this court make a decision, send back down to the state of Desmond ordering a plea agreement, because it would potentially create a state sovereignty issues. But what courts have done, what the circuit courts have done, is vacated the charges or remanded the case with instructions not to be inconsistent with the decision of this court.
Well, when you make that kind of determination, when the court makes that kind of determination, you get back down there and she wants to take a plea until she finds out that the officer who was going to testify has moved on, and he's no longer in the jurisdiction, he's no longer a police officer, and the people don't have a case anymore. I would assume at that point she would like to have her second trial.
Your Honor, I imagine that she would, but in that factual, in that narrowly tailored hypothetical, Your Honor, again, it's petition. If the Strickland test required this fundamental fairness to the criminal defendant, not to the state. And in fact, when this court said in the United States versus Morrison in 1980 that any remedy needs to be narrowly tailored, that's exactly what we would be doing today. We'd be saying we will release all the charges against Ms. Smith unless she's put back in the same position. And that wouldn't be run counter to this court's decision again in Hill versus Lockhart, Iowa v. Tovar, or Padilla versus Kentucky. This court has been clear that Sixth Amendment rights attach at the plea bargain stage. This court has never said this only attaches when a criminal defendant pleads guilty. Now, Your Honors, again, looking at the circuit's decisions, they are very factually analogous to what we have here. We have a draconian penalty that was put on to Ms. Smith as a result of counsel's ineffective assistance. And there's a reasonable probability, just a reasonable probability, that she would be in a better position but for counsel's ineffective assistance.
When Strickland talks on that point, when Strickland talks about a reasonable probability that the results of the proceeding would have been different, doesn't that reference the results of the trial? mean, at least in the context of Strickland, I think it did.
That's right, Your Honor. But Strickland was also, with the United States versus crime, said that you must consider, again, the totality of the circumstances. And now here, in conjunction with the court's previous decisions related to the attachment of Sixth Amendment rights to the plea negotiation process, this wouldn't be stepping out of bounds of what the intent of Strickland was, which is to put the petitioner in a position they would have been but for counsel's ineffective assistance, and at the same time, to give fundamental fairness to criminal defendants. Now again, Your Honor, not affording Ms. Smith the opportunity to be put in the same position she would have been is to open the door and to potentially allow prosecutors, not to allow counsel's representation to not tell them potentially about plea agreements or to keep them hidden. This court has already said that the plea negotiation process is a critical stage of criminal litigation. And as a result, we ask that you vacate or reverse the charges against Ms. Smith with an instruction not to be inconsistent with the holding of this court.
Isn't another possibility that pleas just won't be offered anymore because the government doesn't want to take the chance of getting faced with this situation when they've gone through the trial and now they've got to do it again? Maybe what about the possibility they'll say this just is not worth it to us?
Respectfully, Your Honor, with the number of crimes and pleas and the weight on the judicial system already, it would be rather interesting for a prosecutor to not offer plea agreements in the future. And it's been the same thing as we've gone out through. I see that I'm out of time, Your Honor. Can I continue?
Please.
It's the same. This instance is the same as a Fourth Amendment right issue, where when we have issues related to a Terry stop, will that change the nature and the scope of how we treat potential criminal defendants? And we saw that over time, we've provided more fundamental fairness. And that's all that the Strickland test requires, and that's all we ask for Ms. Smith today.
Thank
Your
you.
Honor.
Mr. Sefalco? Please begin.
Your Honor, Chief Justice, good evening. I'll be arguing on behalf of respondent of the state of Desmond, and I'll be obviously first be addressing the First Amendment claim of petitioner. Let me first state that the state respectfully requests that the decisions from the courts below be affirmed, and it states position that Tinker was correctly applied in the courts below. And we also have findings of fact from a trial court in Desmond, and we also have an affirmation of those findings in an intermediate court. To begin, schools are different, and the precedents of this court have established that. And if I may just borrow a line from Brown v. Board of Education, education is perhaps the most important function of state and local governments. And that's exactly what we have here. And then further,
Counsel, the First Amendment's kind of important too, isn't it?
Yes, Your Honor, it is. And again, to go further, the Board of Education versus Pico, which is a 1989 case, recognizes the obligation of schools to instill some sort of moral character or modeling of what good behavior is. And the school has a function beyond education, and they obviously have an interest in the free exchange of ideas and civil discourse, but not, it is limited. In some cases, it's not coextensive with adult public discourse. And since Tinker and the substantial disruption test, and I'd like to point out that petitioner characterizes the speech that occurred here as both outside of the realm of school's control because it was outside of school, and passive in its nature. And Tinker was the control of the school, and the state court's opinions were reversed because the speech was found by this court to be pure, and it was found to be passive. There was no substantial disruption. And here we don't have a case of pure speech or passive speech. We have a student who's who's imploring other students and faculty for what amounts...
They're not really imploring. It doesn't, the blog doesn't, the posting doesn't really read like a call to arms, does it?
Your Honor, that's correct. The tone in the blog post makes a statement in the beginning, basically just says that it's canceled, which was a misrepresentation. It wasn't canceled, it was rescheduled. And within that blog post, there's also references to the email that was sent earlier. And I think it's important to note that we can't, when we look at the school's discipline for behavior, we cannot necessarily, because this email was sent and it's referenced later in this blog post, we might not be able to totally separate those two acts. I mean, this all happened within 24 to 36 hours, and the school adopted a measured response and didn't act for several weeks. But that's not necessarily unreasonable under the circumstances. And when they decided to act, they explained to the student, Ms. Smith, what the reasons were.
But they didn't act until the blog post was discovered, right?
Yes, sir.
The disruption had already taken place, the calls had been made and so forth, and it was sometime thereafter that I recall the principal's son pointed out the blog post. So,
Yes, sir.
I mean, it does seem that the action that was taken was a result of the blog post and not what had happened previously. Isn't that true?
Your Honor, while the blog post was not brought to the principal's attention till several weeks later, the disruption occurred in a focused period of time, 24 to 36 hours, and it does not seem unreasonable to the state that the administration would wait a period of time. And if you look in the references in the record, that the principal did not want to act any further because she didn't want to disrupt the student from her studies and exams. And that's reflected in the record as well, that there was a reason for the delay to a certain extent. And
Well, if I understand from the record, she didn't want to take any action on the day that the exams were being taken, but then nothing happened until sometime thereafter when the blog post was discovered. So I just question your argument that it was really based on both the initial email and the blog post. It seems that it was based more on the blog post.
Your Honor, the final decision to discipline the student may have been based on the administration's finding of this blog post, but again, because it references the email and the character of it is very similar in terms of what it's asking people to do. And I think it is not critical to this case, but important to note that the student made a misrepresentation that caused alarm for really no reason. And the issue, as quickly as it was decided to reschedule, was resolved.
You think that misrepresentation constitutes part or played a role in the substantial disruption that occurred?
Yes, Your Honor, and the reason being is that the school made, and again, I would just like to highlight the fact that this court, through the exceptions to Tinker, as well as Tinker, has provided a tremendous amount of deference to schools within reason to regulate students' behavior.
What's the disruption here? Is it just getting all the phone calls?
Your Honor, the disruption was the en masse response, right, from concerned faculty, parents, and students.
If somebody gets upset with the school taxes and says, not a student, I'm just a regular old taxpayer, says, I think we got to call the principal and tell them that we don't like this thing, and are they a poor citizen for doing that?
Your Honor, you're absolutely correct, and I think that's what causes some confusion here, is that this is a mechanism. What happened, what was a result of the disruption was a mechanism that we would expect concerned parents to call the school and find out what's going on. And that would normally not be unreasonable, but it was manipulated here. That sort of mechanism that we would normally accept as proper behavior was manipulated by a student. I think if everyone...
Manipulation was what?
The manipulation was the misrepresentation that it was canceled unequivocally and that it wasn't for a well-reasoned decision based on safety, and that alternatives were provided. And that was all known to the student immediately, but she chose not to represent it that way. And I think that's what triggered the concern, the en masse response, which disrupted faculty. And again, this is a finding of fact, and that was affirmed at the intermediate level. A finding of fact that faculty were diverted from, well, the administrators, right, were diverted from their basically staff development day, returned to school to address the concerns of parents, because they have an obligation to address the concerns whether they're legitimate or not. So I think the administrator was acting correctly in that respect, but it was completely unnecessary. It was caused by the student.
What if the student had made the same type of, posted the same type of blog post, but instead of the dance, it had to do with the school's decision to terminate a certain teacher that the student liked, and if the student had said in the blog post, why don't you call the office and encourage them to retain this teacher? And that resulted in a massive phone call and emails to the office. Would that be subject to discipline?
Your Honor, I understand the issue of characterization, but a disruption is a disruption. And the schools,
So that, you would say that's poor citizenship, that's what we're charging this gal with. And similarly, if she knew that there was a student who was being mistreated because, let's assume she's Muslim and is dressing as a Muslim, and the faculty doesn't seem to be doing anything about the bullying that's going on here, and so she calls her people and say, call the principal and tell them that something's got to be done here. That, in your view, would be a disruption and therefore poor citizenship for which she should lose her scholarship to college.
Your Honor, yes, but I find that the missing link in that analysis and those conclusions is that the school is not. This isn't just about disruption. It's about the school's discretion in disciplining students because they want to promote a certain type of behavior.
So if the school said, if all of these calls had been because one of the basketball players had been suspended and we agree that he should not have been suspended, thank God you did that because you brought that to the school's attention and that athlete now is playing and we're going to win our championship. But if it's for the reason that we have some minority who's wearing funny clothes and you're going to bother us with that, well, that is just poor citizenship and we're going to write you up for that.
Your Honor, I think that I believe with the precedents we have here and the exceptions we have here, that it's within the school's discretion again to model.
And you would
student
accept that?
behavior. Yes, Your Honor.
Okay.
So the state does not allege that any of the Tinker exceptions apply. We have Frazier, bars lewd or vulgar speech in school speech. The school doesn't need to demonstrate substantial disruption in that case. We have Hazelwood School District versus Kuhlheimer, which is school-sponsored speech. A school newspaper didn't want to publish an article about pregnancy. Again, the school's name is on the paper, so school-sponsored speech, the school can discern what it wants to attach its name to and what it doesn't. And again, it doesn't have to demonstrate substantial disruption. And finally, this is a very recent case, 2007, is Frederick v. Morris, which came out of the Ninth Circuit and went to this court and was reversed and sent back down and vacated. And basically, the issue there was at a school-sponsored assembly, a student unfurls a banner advocating the use of marijuana. Again, this court found that school could, without reason, just generally, on principles, protect students from that kind of advocacy of drug use. So we've got a number of exceptions. The state's not claiming that any of these apply. We're claiming that Tinker applies and that the disturbance occurred. And this is, again, a finding of fact in the trial and intermediate levels below. The issue, and again, sort of and petitioner cites Snyder versus Blue Mountain School District as a case where the school is unable to pass the Tinker substantial disturbance standard. And in that case, I'd like to distinguish the student outside of school hours at home creates this MySpace profile that's very derogatory of an administrator. But again, that is passive speech to a certain extent. It's pure speech in the sense of you're saying very derogatory things about someone, but you're not advocating any kind of action or directing disruption to the school. And that was what they found in that case. In Blue Mountain was that this is out there on the internet, people can view it to a certain extent, but the student limited the profile, limited its distribution, but it's just out there, and it's not reaching back like this activity was. It wasn't reaching back into the school. And I think that's where we established the nexus, and Blue Mountain does not. Is that yes, it happened outside of school, but it reached back into school, and it distracted the students, and it diverted the administrators, and that's where we're claiming the disruption occurred. And again, we respectfully request that the decision be affirmed, because we have a finding of fact from a trial court, and we have it being affirmed at an intermediate level, and petitioner here has not presented anything to the contrary in terms of what the record shows. I think it's clear from the intent of the blog, and I'd also just said, as came up earlier, that the school only need to show reasonable, like a forecasting of disruption, and not necessarily that a disruption would actually occur. And here we have a student who, based on the language of the email, which was included in the blog post.
What was the forecast of just, let's assume that the school got no emails or phone calls after the email and blog message was posted.
Right.
What is the forecast of disruption that you claim is foreseeable from those posting, or from the email and the posting?
Yes, Your Honor. it's the student demonstrated an intent to disrupt. And so it would be,
How?
because she made a misrepresentation that caused concern, which triggered, and she was requesting for what amounted to be really no useful purpose. She requested that people contact the administration. And when she made that request, the administration saw, okay, we have a student here who is seeking to sort of disrupt the process and distract, and there's really no useful purpose of it. Her speech was not useful in any way. It wasn't about some sort of exchange of ideas or discourse, and she had a responsibility, and she was on notice as to what her responsibility was as a member of the student government to maintain open channels of communication with the administration, and she failed to do that. And so, again, going back to the school's broad discretion in disciplining students, they decided that wasn't a model of behavior they wanted to promote. And so they barred her from running for student government again, they removed her, and the discipline is reflected in her record. But I'd also just like to go back to the petitioner makes a claim that she was somehow deprived of an education, and she was not deprived of an education. She can go to school.
Deprived of a scholarship. I mean, that's an injury, isn't it?
Your Honor, I'm not sure if it's an injury. I'm not sure if the school is within its bounds here. I mean, it's operated to her detriment. I'm not sure if it's an injury that the administration is responsible for, but she still has the opportunity to go to school. And
One of the things that occurred to me while, I mean, we're after Ms. Smith here for what she did, but apparently whoever made the calls was operating under the same misinformation that she was. In other words, it wasn't like she sent this out and said, well, everybody knows it's been postponed to another date. Otherwise, they wouldn't have made the call. So the administration had to have done something that led enough people to believe that it had been canceled for them to get this firestorm back. And I'm wondering why, because Ms. Smith sends this blog out saying, you know, that they've canceled this thing, and everybody gets upset and says, well, she misrepresented that it in fact had only been postponed. Apparently nobody got that message, right?
well, Your Honor, the student did not indicate in her initial correspondence, right, when they send this email out, they don't communicate that why it was canceled or that it was already, there were two options for rescheduling. And she mentions that in passing later in the blog, but still encourages people to call. And it served no useful purpose. To go further, the petitioner is asking for a ruling by this court, basically to invalidate the judgment below based on an unconstitutional as applied standard. And it's tempting because it's a narrow standard. And this court could rule in petitioner's favor and make an exception that is extremely narrow and apply to these circumstances. But as it relates to school speech, it's simply not appropriate. The school has a tremendous amount of discretion to model student behavior.
It sounds like, though, your argument is that they have a right to be wrong, but the student doesn't. And if the student makes a mistake, let's assume it was an honest mistake that she didn't know that that had been rescheduled. The school can nevertheless overreact to the extent of saying, just because you made that mistake, we're doing 1, 2, and we're gonna see to it that you got to pay for college. And you're saying that's not subject to review because it's within your discretion.
Your Honor, I understand that the school's ability to create this sort of blemish on a disciplinary record is substantial. The effect is substantial. But the school provided reasons, and the school's sort of code of conduct is very general. The student was on notice as to what that was. I'm out of time, Your Honor. May I briefly conclude?
Certainly.
Again, petitioner is requesting an as-applied unconstitutional. He has an as-applied unconstitutional claim here. And as it relates to school speech and the facts of this case, he's asking you to consider the facts of this specific case. The claim it's not a legitimate claim. It's not. The facts here do not dictate a reversal by this court on the First Amendment. Nothing further.
Thank you, sir.
Now, do you sit down and stand back up?
Your Honor, if I may just grab a sip of water.
That's allowed.
Your Honors, with regard to petitioner's Sixth Amendment claim, again, it's the state's position. We respectfully request that the decisions of the lower courts be affirmed. We agree that Strickland is the applicable legal standard here, but that it was correctly applied by the courts below. And again, this evening, petitioner first struggled to articulate a substantive or procedural right in terms of a plea that was violated, not effective assistance of counsel, but a plea. And second,
Well, you agree, of course, that the defendant has the right to effective assistance
Yes.
of counsel as part of the plea process.
Yes.
There's the right to to good advice so that he can make a knowing and intelligent choice as to whether he's going to accept the plea or not.
Your Honor, the state concedes absolutely that there's a Sixth Amendment right to effective assistance.
So why shouldn't we treat those claims the same whether the defendant accepts a plea or rejects a plea?
Your Honor, the issue, and it is the state's position that and as you stated earlier, is that those two actions, the two choices are not legally congruent, and they don't have legally congruent consequences. When you accept a plea, and all the precedents in this court deal with the acceptance of the plea and how it prejudices the defendant, you are ceding the rest of your Sixth Amendment rights. Confrontation of the witnesses presented against you, and the other elements of the counsel clause. So you are ceding rights. When you reject a plea offer, it leads to the full exercise of rights. If you proceed to trial, you are exercising your Sixth Amendment right to its greatest extent. And in this case, we have a trial for which the petitioner does not contest the fairness or the fullness of. So,
But she was deprived of at least an opportunity, right, for a more favorable result, clearly based on substandard lawyering by her attorney. Isn't that right?
Your Honor, she was presented an opportunity, and I would just like to highlight that in every case, an attorney may make a recommendation based on their experience.
But this wasn't, I mean, this recommendation was based on him not reading the statute.
Ignorance of the law, in this case, Your Honor, yes.
You're not arguing that his advice was somehow within the range of reason. It was poor, correct?
Yes, Your Honor. The issue here is, as was discussed earlier, is the prejudice. Is step 2 of Strickland. And that's the stumbling block in every case where Strickland's applied, is a defendant's failure to show prejudice. And it's not, in this case again, as was determined by the courts below, the second prong of Strickland isn't satisfied.
The second prong of Strickland asks whether there's a reasonable probability that but for the unprofessional errors by the lawyer, the result of the proceeding would have been different. Isn't that the case here? We're talking about a criminal proceeding, not necessarily just the trial.
Your Honor, you're correct, but there's other portions of Strickland where they again, addressing prejudice, they speak specifically to prejudice in the adversary process.
Shouldn't we expand Strickland?
Your Honor, the problem with expanding Strickland is that, and just to put some context, as the way Strickland was articulated in a case where the defendant was claiming error on the part of the attorney in sentencing. And it's much easier. It's easier to objectively determine whether or not an error by a attorney. In this case, it was in Strickland, it was the failure to raise an objection. The court found that it did not prejudice the defendant in that case.
Why isn't there prejudice here when a decision is made by a defendant in the context of a plea offer based on poor advice? Why doesn't that alone establish prejudice?
Your Honor, again, it's a matter of, at trial, it's very easy to see when an attorney fails to present a witness or examine certain evidence or cross-examine a
Well, I'm not saying that it's
witness.
an easy question. It's easier at trial.
Yes,
That's not what we have before us.
Yes, Your Honor. The problem with the analysis, when you reject a plea, is again, we proceeded with a full and fair trial. It's difficult to look back and say where the prejudice occurred or really if any prejudice occurred, because it lends itself to a more subjective analysis, and that's what the case law of this court forbids. It cannot depend on mere outcome determination.
Well, shouldn't there be a hearing of some sort
Your Honor, a hearing on the evidence of...
as to the ineffective assistance of counsel? Because if you've got a lawyer who didn't even read the statute and gave her flat out bad advice, he also may have left opportunities on the ground that he could have asserted, sealing the record, youthful offender, any number of things that would have protected her record, knowing that she was a student, and the ramifications for her going forward were such that the plea was clearly the best interest. Would you agree?
Your Honor, I think the record at this point does not reflect what the best option. I think there's some inconsistencies. I think there's some inconsistencies in terms of what the defendant might have done. If you examine, the defendant's claiming a harm based on she basically was unaware of what her exposure would be when she went to trial. She was convicted on all 5 counts. And I'd also like to point out at this time that the evidence presented against her at that point in time is uncontested. It's airtight.
That's what makes you want to think that the plea would have been a better option.
Yes, Your Honor, I understand that, but I'd also, there's a case in the Second Circuit, and this is older, 1991, Strauss versus Leonard, where the court comes to the conclusion that strong evidence may negate prejudice. Where you're looking for prejudice, if the evidence is overwhelming against the defendant, it's not really clear.
That's in the context of the trial, right? In other words, he can say, there was errors by my lawyer, and say, yeah, but your confession and your fingerprints on the weapon were kind of to make that a harmless error. As opposed to this, where we don't know. It looks like she should have taken the plea. There's no reason in her right mind. She knew, that she was texting. She knew, that the officer could testify to that. She probably knew better than anybody that she was going to get cooked on this thing.
Your Honor, I think the state contends that we need more than some sort of post-conviction self-serving statement on the part of the defendant to determine if that's the case.
What would you like? What would make you think that a lawyer in a situation would require reversal on an ineffective assistance of counsel?
Your Honor, and as petitioners pointed out and has advocated for, an application or a remedy based out of the 6th or 9th circuits. And it's the state's position here. We're not sure what the remedy could be because the 6th and 9th circuit.
No, I'm saying, what should she have shown? You're saying she didn't show ineffective assistance of counsel.
Your Honor, we believe she needs to produce either witnesses who were present when the plea was discussed with the attorney, some other sort of documentation or testimony from the
You're
attorney.
saying there should be a hearing?
Your Honor, not necessarily.
How are you going to get witnesses without a hearing?
If there's anything in the record below, from the courts below, that could be examined by the court to determine whether or not there was a reasonable probability that she would have accepted the plea. The
What
court
about an affidavit from her lawyer?
I'm sorry, Your Honor, what about an affidavit?
From her lawyer and her lawyer says, I screwed up. I didn't know the statute was in place. It was a new statute. I hadn't read it. I gave her bad advice. And she says, boy, if I had had this information from my lawyer, I would have accepted the plea. Who else is part of those conversations? What else are you going to have?
Your Honor, and that is, it's the state's position that is the issue here, is that there isn't enough to say with any sort of reasonable probability that she would have accepted. And I also think there's an inconsistency. When we look at the harm claim by the petitioner here, she wasn't aware of her exposure, this character evincing moral turpitude mark on her criminal record, and the 10 days versus the 3 days she would have received at the plea, they were misdemeanor counts.
Can you give me an example of where you would find ineffective assistance of counsel with the first one of these?
If, Your Honor, and there is some precedent in the circuit courts for this, if there was a gross underestimation as to what the consequences would be here.
What in your mind would be the prejudice that would amount to a situation where we should reverse?
Your Honor, it would have to be a failure to communicate the terms of the plea, an outright failure to communicate or allow the defendant to consider the terms of the plea, because that's a decision ultimately made by the defendant. While the attorney might provide advice, it's a decision made by the defendant. And in cases where the defendant where the defendant was not informed of the material terms of the plea.
Isn't it possible that she could be informed incorrectly?
Well, yes, Your Honor, but in this case she was informed of the exact
No,
material
I'm
terms.
still trying to pin you down on one where you would say that there's sufficient prejudice that the conviction should be vacated. You're saying if she never heard about the plea, you would say that ought to be vacated.
Yes, if the attorney, in other words, indicated to a prosecutor that they weren't interested without allowing the defendant to consider the terms of the plea.
I'm saying if she was advised of the plea but advised incorrectly, Would that be enough for you?
Advice, Your Honor, or advice as to, is this material information about the terms of the plea or advice from the attorney?
I mean, you can make it up, because I'm trying to figure out where you want to draw your line.
Yes, Your Honor. If she was, trying to think of how to present this, if she were incorrectly advised as to what the terms of the agreement were, which she was not in this case, if she were incorrectly advised as to what the terms were, that might constitute ineffective assistance. Here, the terms were communicated to her correctly, and she was allowed to consider them. And yes, the attorney gave advice, but he was not obligated to give advice one way or the other. And this court's been reluctant to establish exactly what an attorney in terms of collateral consequences needs to present. And I know Padilla addresses it, but it's in an immigration context, and it's not in other criminal proceedings. And if you look at Justice Alito's concurring opinion in Padilla, he says there's this host of other consequences that criminal defense attorneys are not required to present. And we do that because we don't want to create, we need to preserve independence of counsel, and creating all these additional standards.
It seems to me a mandatory sentence is not a collateral consequence. It seems to me that a mandatory sentence that's associated with the conviction is something that is required to be discussed by her lawyer. And it's not, I say it's not a collateral consequence because it's not something that's specific to her. If she gets convicted, if anybody gets convicted of this, this is the minimum sentence, and this is what happens to her. And these are the moral turpitude results.
Yes, Your Honor. The circuit precedents in terms of not correctly communicating your exposure in terms of sentencing, where ineffective assistance claim is validated is when it's extreme.
So are you
Exposure to 10 years
Is it your
instead of
position
20.
that he wasn't ineffective at all?
No, Your Honor, I'm not saying that he wasn't ineffective. It's that he provided the terms of the agreement, and she was aware of the charges against her, and ultimately it was the defendant's decision to reject it. The attorney may have provided poor advice, but he did not induce the defendant to accept that agreement.
To reject it, you mean?
To reject that agreement. All of the case law in this court, Your Honor, deals with situations where it's acceptance. And petitioner also cited Hill v. Lockhart and talks about where the Sixth Amendment attaches. And I think in our analysis here, it could attach at birth and it would not matter, because the issue is prejudice, is showing prejudice. And we haven't been able to demonstrate prejudice here. And Hill v. Lockhart specifically says, he's talking about acceptance of a guilty plea. The defendant accepted a guilty plea and was prejudiced as a result. And as we said earlier, the consequences of acceptance or rejection are not legally congruent. Maybe
So you're saying that his conduct, the poor advice that he gave him, or that the advice that he failed to give her, was not a mistake that harmed her defense?
Your Honor, no, the record shows that he provided an adequate defense. It was her
That
rejection.
was my question. My question was that the mistake that he made when she had the plea offer available to her, you're saying that's not a mistake that harmed her defense?
I'm sorry, Your Honor, could you read just the last 5 seconds?
Okay, we're focusing on the ineffective assistance in the context of the plea offer. It's your position that the mistake that he made during that process, during the plea process, was not a mistake that harmed her defense?
Your Honor, it did not harm her defense at trial. And I think we don't know, we just don't know.
Well, that's the question. When we talk about harming the defense, do we limit it to the defense at trial? Isn't a defense lawyer hired for every proceeding that's associated with a criminal proceeding?
Your Honor,
Pre-trial, post-trial, sentencing?
Your Honor, I understand your concern, but there is a discrepancy. There's a contradiction between stating that effective assistance attaches in the plea process in either acceptance or rejection, and what was stated in Mabry v. Johnson, which is accepting a guilty plea is what it implicates the Constitution. So we have a contradiction here. And it's the state's position that our position is consistent with this court's precedents. Petitioner is asking for an application that has been used in the 6th and 9th circuits and really requires no more than examining the record. In the 6th Circuit, they examined testimony from the defendant and the defense attorney. But a post-conviction self-serving statement, examining the record and simply saying, well, he received a much greater sentence after trial, therefore he obviously would have taken the plea, and forcing a state court to offer him the plea agreement again, and that's another issue. All of these cases where they allow a defendant to reconsider a plea, and that's it's either the decision's vacated or it's reversed and remanded to a lower court, usually a federal trial court. The problem is these are habeas petitions, and in a habeas petition, the ultimate resolution is that the court directs the release of the defendant, and there's a custody requirement. In this case, we're talking 3 days versus 10 days. In habeas petitions, the sentences are much longer. Here, the petitioner isn't in custody. So there's a custody requirement. This isn't a habeas petition. So what mechanism does this court have to force a state prosecutor, which is a plea that he offers at his discretion, in this case one time only? What mechanism is there to force the prosecutor to offer the plea again? And in a habeas petition, the blunt force tool that the court has is to just order the release of the defendant. And that's not existent here. So we see a problem with the remedy. Your Honor, I say amount of time if I may conclude. There's an issue, there's a discrepancy. We just don't know whether or not the petitioner hasn't shown the reasonable probability that she would have accepted it. If we look at the language on the tuition assistance regulation, there's 3 criteria that are disjunctive as to what would disqualify her. We have one that emanates from the discipline at school. We have the 3 or more convictions of texting while driving, which creates the moral character evincing moral turpitude. And actually, correction, there's 4 disqualifying factors: a felony and a misdemeanor. And even if she had pled guilty, she would have the misdemeanor. So how can we say that if she'd be better off, we should restore her to status quo ante with the misdemeanor and 3 days incarceration? It's difficult to say, because maybe her only option was total acquittal. Maybe that's why they decided to go to trial. The record doesn't indicate it, but we have an issue here in terms of that reasonable probability. Her exposure still would have disqualified her, and that's the harm in the factual record. That's the harm alleged here, not so much the incarceration. That's an issue, but she still would have been convicted of a misdemeanor. And so I think that casts doubt on the reasonable probability that the petitioner puts forward.
Thank you, Mr. Spock.
Thank you.
Thank you.
Mr. Forster, you have a 1-minute rebuttal?
I believe it's 2 minutes, Your Honor.
I thought you were divided.
Well, only pursuant to the rules of this jurisdiction, only one counselor is allowed to speak. Just a few quick points, Your Honors. First, with respect to the First Amendment claim, opposing counsel stated that there was a reasonable forecast of disruption here. However, pursuant to, in accordance with Your Honor's line of questioning, this blog entry was not discovered until 2 full weeks after it was posted, when any potential for disruption had already passed. And by the state's theory, this means that the petitioner in this case could be punished for language that she posted in her freshman year or in middle school as soon as the principal discovered it. And further, with respect to the Sixth Amendment issue, Strickland has been expanded by Lockhart, by Padilla, and Tovar. This court never stated that the Sixth Amendment only applies to the plea bargaining process when there's a guilty plea. It applies to the plea bargaining process. And here we only needed a reasonable probability that the petitioner here would have accepted the plea deal. And had her attorney been informed, he would have told her the consequences of this crime, but he didn't know them because he did not read the statute. And therefore, there was a reasonable probability that she would have accepted it had he read the statute and informed her of the repercussions of this crime. And thank you, Your Honor.
Thank you.
All rise.
At this time, the judges will score. They will then come out and make the announcements. Thank you.
Yep, shortly. All rise.
Thank you. Please be seated. I want to once again thank University of Buffalo Law School and your faculty and all of you students who came for your hospitality this evening. We've just been deliberating on this case, and I want to begin by saying that you guys just did an outstanding job. As you all know, I'm on the Court of Appeals, and I sit in Albany with 6 colleagues, and we hear lawyers from all 4 corners of the state of New York, and some awfully good ones, and you folks would do very well arguing even in our court, and I know echoing what Judge Perdato said too, and having spent a bit of time in Rochester, your preparation was outstanding, your presentations were coherent, your logic was impeccable, which makes it very difficult for us to come up with a decision in this case. But after we had discussed it and cast our votes, we ruled in favor of the petitioners. So congratulations, your client wins.
If I may say, Mr. Sofoko, you win the singles competition.
So if there's nothing more for us, did you want to ask us any questions? Now that the pressure's off, we'll be happy to answer any questions you may have. I wish I could give you constructive criticism, but I can't think of a flaw. I just think you're just outstanding.
I'll echo what His Honor said. You all know you're good by this point, so you don't need us to tell you. But I'll echo the same thing. I'm just glad seeing folks like you. I'm glad that I'm no longer in private practice.
We're over here just at the bench where it's safe.
Absolutely. Absolutely.
So where's our clerk? Can we stand adjourned?
We can adjourn. We'd just like to thank you on behalf of the University of Buffalo Law School for coming out and helping us and helping us develop our program. So thank you, and thanks for everybody for showing up.
Thank you.